Thank you. This case is Arthur Johnson versus United States. Counsel.
Thank you. If it pleases the court and counsel, my name is Thomas Engel and I represent the appellant in this case. The trial court's ruling, both as to prejudice and to admission, was premised on the notion that Sims' prior conviction had no relevance. Our argument has basically 3 points, and it's basically a construct from a logic course that you might have taken in college. 1, Sims' prior drug distribution conviction had some tendency to suggest that he was currently a drug dealer. 2, drug dealers possess guns. 3, therefore Sims had the motive to possess the gun that was recovered from the glove compartment. The trial court correctly permitted the appellant to present a third-party perpetrator defense that Sims, not he, possessed the gun, but erred in excluding Sims' convictions that would have supported that defense by showing motive to possess the gun in the glove compartment. There was no dispute that at one point, Sims was a drug dealer. He had convictions from 2002. He had convictions from 2011. Those were 10 years apart. So not only was he a drug dealer, he had a pattern of drug dealing over a substantial period of time. He was not deterred by law, not deterred by being convicted. And so that pattern is relevant to suggest that he was currently a drug dealer. This isn't a situation where there was one conviction a long time ago. This isn't a situation where there was several convictions a long time ago. This is a pattern over a period of years showing that he is dealing drugs. The drug dealers have a motive to possess guns. It's a common sense proposition that this court has recognized many times that guns and drugs go together, drug dealing go together. And that's well within the ken of the average juror. People out in the world today, they read the posts, they know what's happening in the world. You don't see articles about burglars shooting other burglars. There's not an article in the Washington Post about burglars defending their territory. It is well known, it is common knowledge that drug dealers possess weapons as a tool of their trade. This wasn't a situation where the defense was just trying to dirty up Mr. Sims. They weren't trying to throw in some sort of rape conviction. They weren't trying to throw in a burglary conviction. They weren't trying to demonstrate that he's a bad guy. They were rather wanting the conviction to use it to show he had a motive to have the gun in the glove compartment. That's basically our argument. I think it's rather straightforward, and I guess I'll save the balance of our time for rebuttal.
Okay. Government?
Good morning. May it please the court. My name is Nick Coleman, and I represent the United States. We submit that the trial court did not abuse its discretion in excluding Mr. Sims' prior convictions. Judge Edelman carefully considered these convictions, the facts of the convictions, the theory that the defense had for why they were relevant. He carefully considered that, balanced the prejudicial versus probative value, and determined after considering all of the factors that they were insufficiently relevant and that the probative value was outweighed by its prejudicial impact. Appellant still has not identified a factor that Judge Edelman did not consider, that he should have considered, nor has he identified a factor that the judge improperly considered or insufficiently considered. And we submit that in this case, Judge Edelman properly considered that these convictions simply were not sufficiently probative. And the reasons why we think are apparent. In this case, Mr. Sims was present in the car, and yes, he did have prior convictions, but there was no evidence of any drug dealing at all in that car. So there was no evidence at the time when the gun in this case was recovered that Mr. Sims or anyone else was actually engaged in drug dealing. And since, as my colleague has argued, The primary theory of relevance here was that Mr. Sims possessed this gun in order to protect himself during drug dealing. Since there was no evidence of drug dealing at the time, the theory of relevance here was extremely attenuated. We submit also that the theory that these years-old convictions for drug dealing alone, not drug dealing while armed or gun possession at all, required a certain degree of speculation on the part of the jury to determine that a drug dealer simply by itself, drug dealing showed a motive to possess the gun in this case. And because of that sort of double layer of speculation, unsupported by the evidence in this particular matter, Judge Edelman simply did not abuse his discretion in determining that the convictions were not admissible. If there are no further questions about this matter, then we would respectfully submit that the judgment of the Superior Court should be affirmed. Thank you.
Just in rebuttal, the government makes the point that there was no evidence that Mr. Sims was, or that there was any drug dealing going on at the time in the car. We can see that, sure enough. But drug dealers don't check out. They don't clock out. They don't punch a time card. You can't be a drug dealer and say, oh, don't shoot me now. I'm not dealing. I was dealing yesterday, but I'm not dealing today, so don't shoot me now. The drug dealers, when you enter that outlaw status, you need a gun 24/7 because someone, when you read the Washington Post, it wasn't that the person got shot because they were dealing drugs at that time. There's retaliation. I mean, we've all read the Washington Post. It's within the common sense of a juror. And so we would submit that rebuts the government's argument there. And in respect to the government's other argument that it's not much, that the prior convictions weren't armed while dealing. That's true. And we would submit that we're not saying that the convictions were well armed. But it's not much of a leap to suggest that drug dealers are often armed, and that's within the ken of an average juror. That all goes to weight, not admissibility. Judge Edelman's problem, or Judge Edelman's error, we would submit, is he said that this is just not relevant, and I think the Hunter case establishes that it is. With that, we'll submit.
Counsel, thank you both.
All rise.
Case is submitted.